This is the General Counsel panel. So following the themes from this morning, listen to your customers. This is a very good opportunity for all of us to listen to our customers. So let me introduce our panel. To my immediate left is Kate Wilford. Kate is legal principal litigation at Anglo American based in London. She manages a range of disputes and legal risk issues arising out of the Anglo American Group's business worldwide. Kate joined in 2019 from Hogan Lovells, where she was counsel in the International Arbitration Team. She's also a member of the ICC Commission on Arbitration and ADR and was previously a member of the Task Force on ADR and Arbitration. To Kate's left is Kai-Uwe Karl. From 2001 to 2007, Kai was in private practice at Cleary Gottlieb in Brussels, where he was involved in cases before the European Court, the European Commission, as well as national regulators. He joined General Electric's oil and gas business in 2008 in Florence, and then was appointed Global Chief Litigation Counsel for GE Renewable Energy in 2016. Now Global Chief Litigation Counsel for GE Renova. He represents his division in disputes worldwide, also leads policy initiatives aimed at managing and reducing the risk of disputes. And then finally, Fabio Solimene. Fabio is Assistant General Counsel at Honeywell HPS, where he manages the EMEA region. Before joining Honeywell in 2022, he was the corporate head of legal at the global EPC contractor Saipem, and before that, a lawyer at Watson Farley Williams. Fabio is also a visiting lecturer at King's College London and is lecturing on the MSc in construction law and dispute resolution. So welcome. I have only 3 questions to ask our panel because we only have 30 minutes. So what I'll do is I'll go through each time and ask one of the panelists to lead, and then perhaps for the other 2 to follow up. To save our panelists saying this, it's probably worth me saying as well that the views that are going to be expressed now are not necessarily the views of our panelist organisations. They are their personal views. And on that basis, can I invite us to proceed on the basis of the Chatham House rule as well? So, Kate, we heard this morning about the last 100 years of arbitration. We're going to hear later about the future of arbitration. So let's make a start on that. You don't have to look 100 years ahead, but what do you see as the types of disputes you think we'll be facing in the future? Thanks, Guy. I was going to pick on one particular topic where I see disputes coming in the future. I'm sure there will be far more categories, and so the categories we're all familiar with will not go away. But the one I wanted to talk about was around sustainability and the transition to a low carbon economy, which I really hope won't take 100 years, because if it does, we're all in trouble. So obviously there have been a lot of high profile disputes in this field to date, but most of them have been non-contractual, so probably of limited relevance to an audience of arbitration practitioners. So we've had, for example, the litigation in the Netherlands about Shell's carbon reduction targets. And similarly, Shell has been the matter of a high profile dispute here in the UK around directors' duties, but they've very much been looking at non-contractual mechanisms, dispute resolution mechanisms, and ways for claimants to exert pressure through litigation. So what does it mean for an audience of arbitration lawyers? I think what we're certainly starting to see at the moment is a lot of clauses going into contracts that are pretty untested and novel, and will probably one day in a few years' time be the subject of arbitration or litigation, depending on the clauses that are in the contracts. So they may be sort of carbon reduction type clauses, they may be other sort of sustainability focused clauses, they may be aimed to support human rights. But we're seeing quite a lot of pressure coming from different angles to put these clauses through. There are some model clauses coming through. I think the Chancery Lane project is probably the best known, but there are also others, particularly, for example, in the oil and gas industry, there are efforts being made to negotiate sort of recognised model clauses that are increasingly going into contracts. But I think given how widely they're suddenly being introduced, there will inevitably in the future be issues around how they're interpreted, how compliance with them is measured,
and what are the consequences of not complying with those clauses. So to be a little bit more specific and break it down, I wanted to talk specifically around carbon emissions reduction. And some of you may be familiar with the notion of scope 1, 2 and 3 emissions, and I'd find that quite a useful framework to think about where the issues may arise and therefore where the disputes may arise. So scope 1 is direct emissions from business activity, and we're seeing obviously lots of large decarbonisation infrastructure projects being built at the moment. I think we can all safely say that large infrastructure projects give rise to lots of disputes. Scope 2 is emissions arising from purchased energy, and so at the moment we're seeing lots of power purchase agreements being entered into with renewable energy suppliers. Scope for disputes to arise there on a contractual basis. And then the one that I think is possibly the most challenging is scope 3, which is the value chain emissions, either upstream or downstream. And that's particularly where supply chain contracts are increasingly containing the sort of clause that I was talking about earlier. And I'm sure we've all dealt with plenty of supplier disputes, so I think there is a new avenue opening up there for disputes in the future.
Thanks very much, Kate. And the scope reference to scope 1, 2 and 3, if you don't know them yet, you will very soon. And in fact, scope 4 is coming as well. So by all means, look that one up. Kai, Fabio, anything to add on that theme or any other themes you want to pick up?
I can maybe just pick up on what Kate is saying, kind of expanding it because I think Kate is spot on in terms of the type of disputes we see. And then you look at the kind of economic environment in which this is happening. So I think there are two defining elements. One is the amount of investments we see, as a result of the energy transition coming in the next years. And the other element is, you look at climate change. Climate change means you need to act very swiftly to stay within the Paris Agreement. So you have a ton of investment in highly complex infrastructure projects, and you have to execute those projects within a very compressed period of time. You have the issues that Kate described, which is a recipe for disputes. And I think many of the disputes we'll see were probably similar to the construction dispute we see in the past. But I think the parameters are changing. I think that's a challenge for arbitration lawyers. What you cannot have is, those disputes taking years and years to resolve. If you have that, it will slow down the energy transition. You need to be swift. And I think that's the challenge for the arbitration community. We've had a discussion for the past decade or so, or even longer, in terms of accelerating arbitration, becoming more efficient. Now it's a much more serious issue because you're in the middle of an energy transition. If we don't get this done, we have much bigger issues.
Thank you. Fabio?
Yes, just quickly adding up on what Kate was saying. I certainly see disputes over decarbonization. I mean, there is this decarbonization effort from states and companies are following up. So this just translates not just in construction disputes, like construction of renewable energy projects. These projects are becoming larger and larger, more complex. So you see offshore wind farms with very large turbines and so on, new technologies. So this will increase the number of disputes and the type of disputes that we see. But also we probably see some, I would say, decarbonization-related disputes, like, for example, the need to scrap some assets, oil and gas assets, decommission some oil and gas assets, or repurpose some oil and gas assets. If you think, for example, about drilling rigs, they might be scrapped at some point, or they might be even repurposed. Some of them may be used, for example, if you want to think a new use in the renewable energies, they might be used, for example, to serve as foundations for offshore wind farms. Then in that situation, can probably see disputes over this type of contracts. And probably also contracts related to shipbuilding contracts, for example, because we need new vessels, for example, for offshore wind farms. And now there are not many out there. So there is going to be an increase in disputes of this type.
Thanks very much. I feel compelled to summarize this because I think there's a really important takeaway in all of this, that we're going to have new types of contracts that are going to be tested. We're going to have types of disputes coming out of energy transition. If we don't find ways to resolve them quickly and efficiently, we might actually slow down the energy transition ourselves. So when we talk about greener arbitrations, we probably need to think more broadly than just whether we do it on a screen or in person. Right, let's move to the second question. I think Claudia may be particularly interested in the answers to this. And I'll direct it to Kai in the first instance. Kai, what do you want to see in an arbitration institution in the future?
Okay, let me start with some good news. Oh, it's good. We've just won an arbitration. Had we a really absolute full victory. We were the defendant in an arbitration, and we actually got money awarded to us. And Claudia was an ICC arbitration. ICC did a tremendous job. Our lawyers did a fantastic job, right? As I said, we were a defendant. We were ultimately awarded money. Now, if you look at the arbitration, just kind of the net outcome of the arbitration, the result of the arbitration is a transfer of roughly $2 million from the other side's bank account to our bank account. $2 million, right? So that's not huge. How much do you think we spend on that? Both parties together, everything. Outside counsel, ICC, everything. Not quite. We spent roughly $4.5 to $5 million. Not we, the parties. So imagine the parties spent roughly $4.5 to $5 million to transfer $2 million from one bank account to another bank account. Guy, that's like if you go with your kids to the bank, right, and say, look, I'll give you allowance of £10 a month. And the bank tells you, yeah, we can transfer the money to your kid's bank account, but we'll charge you £20 for that. So that, I think that should make us think. It doesn't make any sense, right? We need to be doing better. And that's not, I'm not criticizing the ICC because I think the ICC did a brilliant job in this case and how it managed. Our lawyers were fantastic. There was not really, we tried to settle along the way, but we didn't manage. But I think the question for us has to be, so what's wrong here? That just economically doesn't make any sense whatsoever, right?
But how much did you not transfer?
Well, so no, but that's a good point because that's a good point because that's always kind of how those cases are sold, right? We spend X amount of dollars dealing with risk of 20, 30, 40 million dollars. But frankly, I think very often, if the result is $2 million, very good arbitrators, something went wrong in how the parties assessed the risk and what money they threw into the arbitration. So it's not, I'm not criticizing lawyers or the ICC. I think it's everyone involved in this dispute resolution community. And it brings me to, what can you do, what should you be doing differently if you look at an arbitration institution? The way I look at it is that my task is resolving disputes, right? I have different tools. I can go to arbitration, litigation, mediation, expert determination. There are plenty of stuff you can do. What I expect on the other side, on the side of the ICC or any other institution, is that they mirror that the ICC is a dispute resolution institution, that I go there because there's dispute resolution expertise and there are different buckets. And if I pick up the phone and I call the ICC, I get an expert in dispute resolution. And that's so key. Because when I pick up the phone and call the other side and say, look, shouldn't we kind of try mediation and do a settlement? Their response would be, nah, if you guys propose that, must be good for you, bad for us. If the ICC, if there's expertise on that, and the ICC facilitates, not in substance, but in terms of just opening a process, ICC carries a lot of credibility. That's a very different conversation you're having. So that's, in short, what I'd be looking for going forward, that the institutions mirror exactly what we need, not only in arbitration, but across the board, and not only the case manager kind of administration services, but really also kind of being able to direct cases in terms of conflict resolution expertise, saying, look, we have to go there or there and doing this or that.
And in fairness, the ICC Centennial Declaration does actually focus on dispute prevention as well as dispute resolution, and I think it's some important choices of words there. And your reference to that case, I think it's worth thinking about this in evolutionary principles. If it cost parties $4.5 million to resolve a dispute that involved a transfer of $2 million ultimately, evolutionary, that isn't going to work long term. Any comments from Kate or Fabio?
Yes, I do have one. I mean, for me, what is key is transparency when it comes to the ICC or any other institution. And transparency is primarily, I would say, the appointment of arbitrators. So I'd like to understand a bit more what goes behind the scenes. So why did I get that specific arbitrator as a chair, for example? What was the reasoning? And for example, another issue is I'd like to see more the new generation of arbitrators appointed more, probably. Maybe some of them may not be experienced enough for certain type of dispute, but sometimes they might be in a panel with a more experienced arbitrator. So I'd like to see a bit of a change in this regard. And the other point is what Kai just mentioned. I'd like to see the ICC or any other institution as a bit like helping the parties solving the dispute. Well, usually when you have, for example, a construction dispute, you have an EPC contractor and an oil company, for example. You never, I mean, the award is the outcome of the arbitration, but the parties might not want that specific award. A contractor might not want to enforce an award against a client. There might be a client next time. The client might not want an award against, for example, a contractor because they might somehow undermine the contractor financially and reduce competition when it comes to certain types of projects. So what I'd like to see is more like something in the middle between mediation and arbitration. So it's not MEDARB, because MEDARB is like you have the mediation. If the mediation fails, then you have the arbitration, and there is nothing you can do about that. I'd like to see something the other way around. So it should be like ARBMED. So you have an arbitration, and then throughout the arbitration, you have some mediation attempts, which are something that the arbitrators, the same arbitrator, may somehow facilitate if the parties are in agreement, so that you don't end up with an award that somehow just affects the relationship, the commercial relationship between the parties, and has an impact, a huge impact in terms of money and in terms of, as I said, relationship and enforcement and so on. So it helps us, the parties, us as the parties, to reduce costs and to improve relationship with the other party. So that's probably the point that I can see in the declaration. It has been touched somehow, but I'd like to see something more concrete about that.
Kate?
Yeah, I mean, completely echo what my co-panelists have said about cost and needing to keep that under control, but also finding the institutions helping us as the parties find mutually beneficial solutions that aren't necessarily a final award. I did have one other slightly different point, which is around sort of geography and hopefully playing into some of your priorities as well, Claudia, because I'm personally a big fan of the regional offices that the ICC have been setting up. So I work for, having said we weren't going to talk too much about our own companies, I work for a company that is a UK PLC with operating assets in lots of different jurisdictions in various parts of the world. And I quite regularly have conversations with my colleagues about, well, we have a dispute originating in our home jurisdiction between two parties who are essentially from that home jurisdiction. Why can't we just resolve it in that jurisdiction? And that's a very difficult conversation to have sometimes, because it's a difficult balance between needing from a parent company level to have sufficient oversight and sufficient confidence in the process, with wanting to encourage not only the development of dispute resolution capability locally, but also sometimes there are just certain aspects of it that make sense to have it resolved locally. If there are local law issues, if there are language considerations to take into account. And I think, being able to offer the regional offices that the ICC has is a really good tool, a really good option to be able to suggest to my colleagues in those conversations.
Thanks, all of you. I'm not going to attempt to summarise that because I want to leave maximum time for the next question, and we can discuss that over lunch as well, in particular with Claudia. So, looking again a future-related topic, it seems compulsory that we have to use these two letters in every part of the sessions we have. So I'll direct this to Fabio. What are your attitudes to using technology and AI in the resolution of disputes?
If we focus for a second on arbitration and focus on generative AI, so AI that generates something from scratch, just based on data that you input in the system, it all goes down to can the parties have or experts have, for example, memorials, technical reports, pleadings drafted by an AI, just inputting something in the system, and can arbitrators have an award drafted by an AI? Well, if we just for a second assume that the technology is developed enough not to give like a completely irrational results, this is probably an assumption, then you probably have to distinguish between the use, abuse, and misuse of AI. So you can probably use AI in terms of drafting. That's just because that's my idea. That's just because arbitration is consensual. I mean, to the extent the technology is developed enough, and to the extent it's used in a legal way and within the boundaries that the parties have agreed. For example, in PO number 1 or an arbitration agreement, you might probably use that specific tool. You have adjudication, for example, in construction that is quick and dirty, right? It's not precise. Why not having like an AI to the extent that, as I said, the technology allows you to give to reach a certain result, and the parties agree with that, and there is someone, there is the arbitrator probably, and probably also the institution, somehow overviewing the whole thing. And someone takes responsibility for that award, for example, or for the pleadings, or for the report. It's not that because the, for example, delay analysis is being done by an AI, then you don't have, you blame the AI if it's wrong. You have to blame the actual person that then has, looked at it and somehow blessed it. Then you have the abuse of AI. So that means that the parties have agreed that they might use AI and set some boundaries. It's legal, but one of the parties or the arbitrators go beyond those boundaries. Then in that case, I believe that should be prevented and somehow penalized. Then what I call the misuse of AI is the illegal use of AI. For example, forging evidence, fabricating something. And we probably don't have to discuss about that because that's already in the law. That's already regulated. We already have Photoshop photos. If you use a Photoshop photos, for example, a pipe in a construction dispute that is cracked, and that cracked was never there in the first place. It was just Photoshopped in the photo. Then in that case, we already have rules that deal with that. So it's probably something that is already covered.
That's an incredibly thorough answer for such a short period of time. Thank you. Kate, Kai, anything to add?
I think what I'd probably take it back also to the cost theme that we were discussing earlier. I mean, just given the amount of data and documentation that's being generated, I mean, I definitely do see a place for AI and just helping us to manage that burden as long as we do it in a proportionate and transparent way.
Kai?
Yeah, no, I fully agree with that. I mean, kind of looking into the future, you would wish to have a tool. You have, like I mentioned it earlier, you had a Dropbox, and all the thousands and thousands of documents you have in the preparation of your dispute during the discovery phase, you just drop that into a Dropbox, and then you get kind of a chronology out of that, with the key facts summarized. Wouldn't that be brilliant? And if you think a step further, if such a tool would be really developed, what would that mean in arbitration where both parties kind of work from the same set of facts? You have the same documents that are in play, thousands of them. You have a tool you trust. You put that tool, you put the documents into that tool, and you have kind of possibly a factual summary that applies to both, or it's relevant to both parties. That would make arbitration, I think, much more efficient.
I think you've hit a rich seam there, because I know plenty of arbitrators who are looking forward to never having to write a procedural history and an award again. There's another observation that I think is tied into some of what Fabio was saying, and that is that, we currently operate in what Sir Geoffrey Voss, our Master of the Rolls, refers to as an analog world for dispute resolution, and I think there's a mindset change that we need to start thinking about, because evidence, which is the cornerstone of dispute resolution, is a type of data. If your data points are digital, then do you ever need to take it out of a digital world, or do you actually keep it in a digital world for dispute resolution? And if you take that to its logical conclusion, you may not need documents in the way we currently operate them. And this is where I think it really opens up the ideas as to how we can resolve disputes in the future. We haven't got time for that now, but we may have a little bit of time, maybe just for a couple of questions. We would slightly go into the next session. So if there are questions, could I please ask that they are short questions and definitely not speeches? Kim.
Hello, Kim Franklin, Crown Office Chambers. Can I ask the woman on the panel, please, what they are doing to encourage diversity in dispute resolution for the future?
So I think big corporates like the one I work for recognise that we have a lot of buying power in the market, and where we direct that buying power can be quite significant in terms of who we approach for the work, what our expectations of our panel firms are, frankly, who we send the initial email or put in the initial call to when we're putting a piece of work out there. So I think that's the main place that we see our role. I mean, in terms of the arbitral process, obviously, the diversity of arbitrators is a very important topic for the reasons that we've been discussing today, and I'm sure we'll continue to discuss. And there, certainly, I do expect to see, balanced shortlists, just to at least look at the pool and try and widen the pool and see who else is out there. The classic is, obviously you've got to balance that against experience, and there may be a little bit of a mismatch there. But I think looking at the shortlist stage as to who could potentially do this can yield some new names.
And on behalf of the other members of the panel, can I also make it clear that the responsibility to promote diversity rests with all of us, not just the woman on the panel. Any other questions? I think we have one more here, and if we could get the mic to you.
Hello, I'm Jennifer Hayward. I'm an arbitrator and a mediator, and I was interested in what you were saying about modifying the processes that we have to make dispute resolution more efficient and quicker. One of the difficulties with combining the mediation and the arbitration process is that once the mediator becomes a decision maker, often people just tend to sort of keep advocating their case. Do you think from the party's point of view, there would be confidence in arbitrators acting in a more facilitative role, particularly during the procedural stages of an arbitration, or do you think it would be preferable to sort of have mediators appointed in parallel with arbitrators, for example, by the institution, but mediators who don't just work on a sort of one-off basis with the parties, but are there through the proceedings to help them negotiate and resolve procedural issues, for example, and just cut away some of the expense?
I can take that. I mean, I was thinking about the mediation the American way, right, where the mediator is somehow involved in the legal points. And in arbitration, at some point, at each stage of the proceedings, arbitration knows more and more about the case. So it's probably in a position to give the parties somehow indications of where the case is going. And that means giving indication on where they could settle in that specific, it's just a picture of that specific moment, I understand, but it's a bit like what the parties do. For example, we read the documents, we read the memorials, the pleadings, technical reports, we attend the hearings and try to understand where the dispute is going. And if we see that it's going in a certain way, we then pick up the phone, call the other parties and say, why don't we settle these before the award has been issued? I think that somehow the institution, the arbitrators, the ICC might get involved in that process, just helping the parties making the step. Because sometimes you can't do that just because the parties don't speak to each other, don't trust each other. So having someone that has been involved in the dispute, that knows the dispute by heart, at that specific moment, I understand, might certainly help the parties to somehow settle out of court with all those benefits that I mentioned. Maybe
just because I think to your points in terms of having a mediator parallel to the tribunal, I think that most cases is a cost issue. For very large disputes, maybe cases, contracts, possibly, but for the typical case, I don't think you will be able to convince anyone to do that. On kind of whether arbitrators should facilitate settlement, I think the ICC ADR guidelines that were just published are really good. I think they are really kind of a very good summary of many tools you can employ, and they have authority in a sense that it's now much easier to propose this in an arbitration, to say, look, why don't we use the arbitrator to somehow assist the parties in a settlement. You need to be very careful in how you articulate that. But there is certainly a long history of this happening in certain jurisdictions and less in others. If you are now able to say, and read the ICC guidelines, it kind of summarizes the state of play. That's very helpful, I find.
If I may add, that might be challenging because they might give grounds to one of the parties to challenge the award. If the arbitrator gives out too much about what he thinks about the proceeding, so it has to be thought in a certain way that makes sure that the award is then safe if the parties don't reach an agreement.
With given we started 5 minutes late, we're at 30 minutes exactly. So I'm going to stop there because otherwise I will be in huge trouble with Domitille, who is about to join the stage. So in a moment, please welcome Domitille Bazot, who will join the stage and introduce, I think, the next panelist. At the same time, can I please, as this panel leaves the stage, could I please ask you to welcome them as well? And at the same time, could I also please ask, this is the only other thing, for a chair to be added to the stage. I want to just close that last debate with 5 letters. AIENE. So while you're all thinking about that, can I ask you all to please welcome, thank the panel for welcoming me.